Good evening. You're watching Breaking Today News right here on Switch TV. I am Lincoln Wumbogo. Sign language interpreter is Michael Maithia. Now, tonight is the D-Day. The BBI case against, the BBI proponents and the BBI opposers. It's a nail-biting process. We now go live to the Court of Appeal where a 7-judge bench is reading the verdict. Take a look.
Each registered voter any disability a registered voter may have. When the promoters went out to collect signatures of supporters of the initiative, the form of the collection of signatures that they had been given by the IEBC required the supporters of the initiative to also indicate their name, identity card number or passport number, constituency card, county, ward, polling station, mobile number, and so on. These are certainly some of the unique identifiers of a registered voter. A signature or thumbprint is one of them, but is not the only one. People's signature can change with time for various reasons, be it age, injury, or disability of their hands, and so on. And it is therefore unrealistic to rely on signatures only to identify registered voters. By use of modern technology, I believe it is not difficult to compare the information contained in Form A of a registered voter with the information captured in the form for collection of signatures of supporters of a popular initiative and determine whether the person is a registered voter. In view of the foregoing, I do not entirely agree with the learned judge's finding that the IEBC's role under Article 257(4) involves both the ascertainment of numbers of registered voters in support of a popular initiative for amending the Constitution, as well as a verification of the authenticity of those signatures. It follows, therefore, that there is no constitutional or statutory requirement for a legal framework for verification of signatures under Article 257(4) of the Constitution. What is required is a legal or regulatory framework for verification of registered voters. I, however, agree with the learned judges that the administrative procedures that were developed by the IEBC are invalid because they were developed without public participation by a commission that did not have quorum. Next issue is whether the IEBC nationwide voter registration exercise before anticipated referendums. I'll jump a few pages and state as follows. It is evident that there is constitutional and statutory requirements for continuous registration of voters, and this is imperative, as the 76th respondent put it. It is informed by the fact that hundreds of thousands of citizens become eligible to be registered as voters every month. The register of voters must also be updated from time to time as required under Section 8 of the Elections Act. So I come to the conclusion that I find and hold that there is no constitutional or statutory requirement for the IEBC to carry out a nationwide voter registration before any proposed referendum, but the Commission is under a constitutional and statutory obligation to do a continuous registration of voters in each constituency. I further find and hold that in view of that constitutional and statutory obligation, the IEBC should continually sensitize Kenyans about its role and encourage them to continually register as voters, except at such periods as specified by statute when voter registration should not be done. The next issue is whether the proposals in the amendment bill are to be submitted as separate and distinct referendum questions. A plain reading of Article 257 requires that the proposed amendments be reduced into a bill, which is then submitted to the people in a referendum. What is to be submitted to the people is not a question or questions, it is a bill. However, the IEBC may require the people to approve or disapprove the bill by answering a question or questions, either in the affirmative or in the negative. The IEBC, as an independent constitutional body, has the sole responsibility of conducting or supervising a referendum, and it is up to it to determine how the referendum should be conducted, subject only to constitutional and statutory guidelines. For example, under Section 49 of the Elections Act, the question or questions framed by the IEBC must be approved by Parliament. A bill is a proposed legislation and may contain more than one proposed amendment. As stated by the learned judges, the drafters of the Constitution were alive to the fact that a bill to amend the Constitution may propose different amendments. The bill ought to be subjected to a proper public participation where each and every proposed amendment is explained, debated upon, and well-informed views taken before the people eventually vote on the same. That notwithstanding, it is improper to lump together 74 proposed constitutional amendments in a bill. I do not therefore agree with the learned judges that what is to be subjected to the referendum is a question or questions. It is the amendment bill, but the people are to approve or disapprove of the bill by answering a question or questions as framed by IEBC and approved by Parliament. The next issue is whether the High Court had jurisdiction to entertain the petitions on account of the principles of justiciability, mootness, and ripeness. I have defined, in my view, what those concepts mean. Then I've looked at the jurisdiction of the High Court under Article 165, that the High Court has original jurisdiction to determine the question whether a right or fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened. A close examination of the issues raised in the consolidated petitions yields the interpretation that the issues in their very sense are not mere political questions, but are in their very nature constitutional issues requiring the determination by a constitutional court. Going by the nature of the issues raised in the petitions and the jurisdiction of the High Court, as stated above, I find that the issues could only have been determined by the High Court in the exercise of its jurisdiction under Article 165 of the Constitution. In this regard, therefore, the High Court could not have exercised deference as argued by some of the appellants, since, firstly, it had jurisdiction to entertain the consolidated petitions, and secondly, the issues could only have been determined properly and adequately adjudicated upon in a judicial process. That may be perceived by some people as unwarranted judicialization of politics. However, it must be understood that the judicialization of politics in our country is a function of the 2010 Constitution that has in several ways widened the scope of the judiciary and in particular commands judges to defend the Constitution. Whereas judges must exercise judicial restraint appropriately and respect the doctrine of separation of powers, when litigants come to court and claim that any person, whether from the executive or legislative arm of the government, is violating or threatening to violate the Constitution, judges must look into the matter and decide one way or the other. On the issue of ripeness, I have concluded that I find and hold that the petitions were neither moot nor non-justiciable. The petitioners demonstrated that there had been some violation of constitutional values and principles in the way the amendment bill had been developed, had been mooted and processed, and the Constitution was about to be dismembered unless the court intervened. To that extent, the petitions did not offend the principles of ripeness. Whereas the process of amending the Constitution was still ongoing, there was every indication that a majority of county assemblies as well as Parliament were poised to approve the impugned bill, which they eventually did, and thus paved way for a constitutionally flawed referendum. Our transformative Constitution cannot countenance that. Had the learned judges declined to assume jurisdiction on account of the principles of justiciability, mootness, and ripeness, they would have violated their respective oaths of office, which they individually subscribed to. A judge's oath of office requires the judge, among other things, to protect, administer, and defend the Constitution without any fear, favor, bias, affection, ill will, prejudice, or any other political, religious, or any other influence. The learned judges were true to their oath of office. I so find. The next issue is whether it was constitutional for the promoters of the amendment bill to create the 70 constituencies. I dealt with that earlier, and I just conclude to say that in view of the foregoing, I agree with the learned judges that the second schedule to the amendment bill, insofar as it proposed to predetermine the allocation of 70 constituencies, is unconstitutional. Next issue is whether there was necessity for legislation or legal framework on conduct of referenda. The judges, the learned judges held that the Elections Act does not meet the intention of the drafters of the Constitution in recommending that Parliament enacts a referendum act to govern the conduct of a referendum. That notwithstanding, the judges held the referendum may still be undertaken as long as the constitutional expectations, values, principles, and objects are met. I entirely agree. In my view, it is not the absence of an appropriate legal framework that posed the greatest challenge to the amendment bill and the proposed referendum. The political elitism, opaqueness, and lack of transparency that characterized the entire process of the proposed amendment of the Constitution were the greatest impediments. The Constitution, the Elections Act, and the Independent Electoral and Boundaries Commission Act contain broad provisions that can be used to conduct a referendum as long as commitment to adhere to the stipulated principles, values, and statutory dictates is observed. The next issue is whether the civil proceedings can be instituted against a sitting president. This was well covered by my brother, Justice Gatembu. And I'll just say, quote, in a decision, Kenya Human Rights Commission and another versus Attorney General, where I sat with Justice Gatembu and Justice Murgo, the court held, and I quote, in effect, a plain and ordinary interpretation of Article 143(2) would infer that the President's immunity is limited to proceedings instituted during his or her term in office, and two, to anything done or not done in exercise of the President's powers under the Constitution. Put differently, the immunity does not extend to acts or omissions that have resulted in civil proceedings commenced prior to assumption of office of the President, or that were not, sorry, let me take that again. To anything done or not done in the exercise of the President's powers under the Constitution. Put differently, the immunity does not extend to acts or omissions that have resulted in civil proceedings commenced prior to assumption of the office of the President, or that were not in exercise of the President's powers. I'll skip the rest of the quotation. I have not been persuaded to hold otherwise. The President of Kenya does not enjoy absolute immunity against civil proceedings during the tenure of office, and neither is the President above the law. He is subject to the Constitution. However, no civil proceedings can be instituted against the President during the President's tenure of office if the complaint is based on any act or omission of the President in the exercise of the powers conferred upon the President by the Constitution. If the President, in his or her own private capacity, not in the exercise of the President's constitutional powers, were to do anything against a person's private rights, that person would have liberty to file a civil suit against the President in his personal capacity during the tenure of office of the President. But if the President, in exercise of powers conferred by the Constitution, does or fails to do anything that is alleged to be contrary to the Constitution or statute, civil proceedings can only be instituted against the President when his or her term comes to an end. Going back to the issue number 14, was the appellant, the President, Mr. Uhuru, was the appellant, Mr. Uhuru Kenyatta, afforded a fair hearing? To answer this question, I shall consider whether the appellant was served with the petition number 426/2020 and a hearing notice, and therefore are given an opportunity to be heard. Rules of natural justice require that every person must be accorded a reasonable opportunity to be heard before an adverse decision is made against them. If that is not done, any resultant decision that aggrieves the person is a nullity, as was held in Onyango Olo versus Attorney General. Counsel for the appellant submitted that there was no service of the petition upon their client. The petitioner, Isaac Aluchir, filed an affidavit of service dated 16 January 2021, in which he stated that he electronically served the appellant as it was impossible to effect personal service upon him. The email address he used was cos@president.go.ke. The record of appeal shows that on 21st of January 2021, the trial court directed, and I quote, all petitions in the 7 petitions to serve the petitions on all the other parties by close of business on 22nd January 2021. The Deputy Registrar to facilitate the process where necessary. The respondents, interested parties, and amici to file their respondents to the various petitions within 14 days of tomorrow. Then the record, I've looked at what it shows. It kept on showing that the first respondent, who was named in his personal capacity as Mr. Uhuru Kenyatta, was unrepresented. So I proceed and make the conclusion that, but assuming the email address that I have read is the official one of the Office of the President or State House, the petitioner did not demonstrate that it was proper to sue the President in his personal capacity, but purport to effect service upon him through the official email address of the Presidency. In my view, the petitioner should have sought leave to effect substituted service by way of advertisement in the local newspapers if he could not get the personal email address of the President. Considering the kind of orders that were being sought against the appellant and the effects of grant of the same, the trial court ought to have been satisfied that there had been proper service of court process upon the appellant. I find and hold that there was no proof of service of the petition and the hearing notice upon the appellant. The appellant's constitutional right to a fair hearing, as guaranteed under Article 50 of the Constitution, was violated in that he was condemned unheard. Consequently, all the orders made against Mr. Uhuru Muigai Kenyatta, as named by Mr. Olucher in his personal capacity, cannot stand. I would therefore set aside the declaration made by the High Court that Mr. Uhuru Muigai Kenyatta contravened Chapter 6 of the Constitution. Next issue whether the proceedings against Mr. Uhuru Muigai Kenyatta res judicata. I proceed to make the conclusion that, on my part, I cannot fault the findings made by the learned judges. I agree with them that the issue as to whether the President could establish a committee to initiate a change or amendment of the Constitution outside the remit of Articles 255 to 257 of the Constitution had not been raised in the earlier petition. The learned judges were therefore bound to hear and pronounce themselves on that important issue. The next issue is whether the Constitution Amendment Bill 2020 violated Article 43(1)(a) in view of the COVID-19 pandemic. Article 43(1)(a) states as follows, and I quote, "Every person has the right to the highest attainable standard of health, which includes the right to health care services, including reproductive health care." Mr. Omoke argued that the President was in total violation of the Constitution when he authorized or used public funds to initiate and promote the impugned bill amidst the COVID-19 pandemic. His argument was twofold. First, that since the country was and is still engulfed by a pandemic that poses a serious health challenge to all, the state should have prioritized the fight against the spread of COVID-19 virus by allocating sufficient resources rather than engaging in political activities. Secondly, the President and his agents, by organizing or attending what he termed as, I quote, massive super spreader events, including rallies and signature collection to promote the BBI agenda amidst the COVID-19 pandemic crisis, was a violation of Article 43(1)(a). It was also in disregard of the COVID-19 directives and regulations issued by the President himself and the Ministry of Health, banning public gatherings, maintenance of social order, and putting on masks, Council added. My conclusion on the matter is that while I agree that holding public rallies that are attended by thousands of people militates against COVID-19 mitigative measures, there was no empirical data or scientific evidence provided to the learned judges to enable them make a determinative finding that the holding of the said events per se amounted to a violation of Article 43(1)(a) of the Constitution. And regarding the amounts that were spent, my conclusion is that I find that there was no sufficient evidence to enable the learned judges reach a finding that the expenditure amounted to a constitutional violation. I will therefore dismiss that ground of the cross appeal. Next issue is whether both or either of the Houses of Parliament were infirmed from considering the Constitution Amendment Bill in view of the Chief Justice's advisory for the dissolution of Parliament. I have found that there were orders that were issued by Justice Korir in several matters. The High Court observed that it was in the public interest not to subject the country to parliamentary elections before exhaustively interrogating the constitutionality of the advisory by the Chief Justice, and that public interest supported the issuance of an order suspending any decision to dissolve Parliament. The amendment bill was tabled before the National Assembly and the Senate on the 4th of March 2021 for the first reading. A vote on the amendment bill was taken in both houses on 6th and the 11th of May 2021, respectively. As at the date of tabling and voting on the amendment bill, the orders issued by the High Court suspending the implementation of the advisory by the Chief Justice were still in force, and there was no indication that the orders had been vacated. Accordingly, none of the Houses of Parliament was informed from considering any of the from considering and or debating the amendment bill, owing to the advisory opinion by the Chief Justice. Next issue is whether the High Court erred in finding that the task force did not create a legitimate expectation on the submission by KNUN that it would be incorporated in the constitutional amendment bill. I've looked at that, and my conclusion is that there is no demonstration. Sorry. In this regard, the fact that the proposals by KNUN were not incorporated in the amendment bill cannot be a basis of invalidating the amendment bill. It was not demonstrated that it was only the proposals by KNUN that were not incorporated in the amendment bill. For these reasons, I would dismiss the appeal by KNUN. Number 20, whether the petitioners had made out a case for disclosure and publication of the steering committee's financial information. I have considered what Mr. Morara said in that cross appeal and come to the conclusion that there is no demonstration at all by Mr. Morara that he requested for any information from the President, Honorable Raila Odinga, and the BBI steering committee regarding the budget and public funds allocated and utilized in promoting the impugned bill. The learned judges cannot therefore be faulted for declining to issue their aforesaid orders. Consequently, I would dismiss Mr. Morara's cross appeal on the issue. And the last one is whether the High Court erred in admitting Amishi Kuria, who were partisan. My conclusion is that, in my view, there is no evidence that the Amishi who were admitted to the High Court proceedings were biased. Their respective briefs were of great assistance to the learned judges in determining the issues I have alluded to. Although the Amishi were not parties to the High Court matters, having been admitted in the proceedings in that limited capacity, in the appeals, the first appellant named them as respondents, and therefore they had to file submissions in reply. I must add that I found the submissions quite useful in this appeal. Disposition. Having determined all the issues that we considered germane in these consolidated appeals, the final orders of the court are as follows. A. We uphold the judgment of the High Court to the extent that we affirm the following. 1. The basic structure doctrine is applicable in Kenya. Sichale J.A. dissenting. 2. The basic structure doctrine limits the amendment power set in Articles 255 to 257 of the Constitution. Sichale J.A. dissenting.
Now, the day-long ruling by the Court of Appeal now only awaits a final verdict of the court's President Justice Daniel Musinga that will seal the fate of the BBI initiative. We are now counting minutes to hear that ruling, but as that happens on, the initiators of the BBI bill, ODM leader Raila Odinga, has issued a statement just a few minutes ago that I will read to you. Raila Odinga says in his statement, the decision of the Court of Appeal today is remarkable as it forms part of the continuing conversation on the future of this country and the significance of our new constitution to the political culture we and the generations that will come after us will practice. It is likely that this is not the end of the conversation and the parties involved will each make their own decisions on how to proceed from the decision that has been delivered today. That is welcome as the issues involved need to be deliberated upon to the fullest extent. For us, as we have stated before, we shall engage only to the extent that circumstances will require, but we feel that we have to move on. This is not an indication of our regard to this noble initiative. Far from that, we feel that we must now see the forest for the trees and pursue the bigger goal of setting the rest of the issues facing this country right. The Building Bridges initiative was never a destination but a journey in an ever-evolving way of life. Without doubt, we shall deal with all the issues in the months and years that will unfold onwards. That's a statement by former Prime Minister Right Honourable Raila Odinga's 7-member Court of Appeal bench will, by the end of today, August 20th, deliver the ruling on the BBI case. We'll be giving you more details. It's just a matter of seconds or a matter of minutes. You can visit our website www.switchtv.ke for more information, or our YouTube channel at Switch TV Kenya or at Switch TV News. Well, for us in studio, it's a wrap. But the conversation continues. Keep on watching, keep on tweeting, keep on sending your feedback to our SMS line 111 444 111. I am Lincoln Ombogo. Our sign language interpreter is Michael Matthew. Good evening.